Can everyone hear me okay?
Mhm.
Okay, all right. Well, my name is Charlotte French Allen, and I'm the Communications Coordinator here at Kansas Rural Center. Thank you for joining us over your lunch hour today. We at Kansas Rural Center have been receiving an influx of requests for information regarding pesticide drift. And to address these concerns, we've invited Roger McEowen, Professor of Agricultural Law and Taxation at Washburn University, to join us today. Professor McEowen will discuss pesticide drift and provide information on what your legal options may be if you have been drifted on. Brian Gertzenberg is also joining us and will provide some additional information from KDA and Drift Watch. To keep this conversation concise, we've muted the audience. Through our registration form this webinar, we have received questions, and you are welcome to add questions to the chat throughout this meeting. We will address them if we have time. This webinar will be recorded and published to our YouTube channel and website. We will remove the Q&A session from the shared recording. After our conversation, we will send an email to share resources with you. In this email, there will be a link to a survey. We ask that you please fill this survey out the best that you can so that we may gather relevant information to continue advocating for you on this topic. We wish to use the data to continue constructively working for a positive action and reasonable recourse on your behalf. Before I hand the conversation over to Professor McEowen, I want to remind those joining us today that Kansas Rural Center is celebrating our 45th anniversary this year. And since 1979, in response to the farm crisis, we have worked to pivot with interest of farmers and their communities to develop grassroots support for needs that arise. This has led many successful programs in the state and is a way of working that we're proud to continue representing today. This webinar, for example, is made possible by our donors. Please consider following us on social media, signing up for our newsletter, and joining us at our annual conference this November 16th in Wichita at the Drury Broadview Hotel. More information can be found on our website, kansasruralcenter.org. And with that, thank you for joining us, Professor McEowen.
All right. Thank you, Charlotte. Good to be with you today. Thank you for the Rural Center for the invitation. And this is an issue that comes up more frequently than we probably anticipate, and I'll get into that in just a moment. Here's my contact information for you, and as an attendee, you have the PDF version of the slides today. And many of you are probably familiar with me. I've been around quite a while. I hesitate to say a long time because that ages me, and I don't feel old, but nevertheless, I was just chatting with Ryan before we went live that I'm just starting at the beginning of August here, my 33rd year of traveling the country and teaching, and I'm almost at 3,000 events for my career. A lot of those are 8-hour events. In fact, I just finished a 2-day 16-hour event in Jackson Hole, Wyoming earlier this week, and on we go. But here we are today, not talking anything to do with tax, something totally different from that. But there you have my Washburn email address, my website address, my Twitter or X handle. And then I've recently started a new Substack publication called the Rural Practice Digest. And there you can see the address for that. That is subscription-based. And I'm about ready to put out the 3rd issue. That's 22 pages each time of usually the lead article is a tax article, something to do with agricultural taxation, and then numerous pages of case annotations and IRS rulings. And then the last couple of pages deal with significant state court opinions involving farmers, rural landowners, agribusiness. And then I also put in my speaking schedule so you can see upcoming events. Well, one other thing I want to just note, this is a listing of the ag-related courses that our students here at the law school can have available to them. For fun, I could put up the next slide, and that would be what the other law school in Kansas has for agricultural related courses, and that would be a completely white blank slide. So we try to take that jab whenever we can. But no, this is, we are the law school for Kansas and for rural Kansas, and you can see the opportunities that our students have there. So one of the selected issues, one of these select issues associated with land use is what we're talking about today. And there are lots of land use related issues that rural landowners face, and pesticide drift is one of those, and it's a function of nuisance law. So I want to start with nuisance law, kind of to set the background as to what we'll be talking about today. A close corollary to this is noxious weeds that spread and damage crops. So you can kind of get the same issue with respect to crop damage with noxious weeds as you can with pesticide drift. And in fact, one of the famous cases in Kansas, now I would say now famous in my realm of this domain, would be the drift of wheat streak mosaic out in western Kansas. And there was a case on that coming out of Rush County, about 25 years ago, about 27 years ago now. And that kind of, I'll get into the details of that particular issue in discussing that a little bit later. But the drift of weeds can also damage crop yields. It's a little bit different. It's a little bit nuanced from pesticide drift, but it's the same principles that apply. When we talk about weeds, as an aside here, before we get into nuisance law, although this is tied into that, farmers do have an affirmative duty to destroy noxious weeds or otherwise prevent their spread. And in doing so, you have to control those noxious weeds, and I'll give you the state list here in just a moment, in a manner that's reasonable, that does not increase the problem. Courts generally don't recognize a common law duty to control weeds that aren't listed as noxious weeds. So if they're not on the state noxious weed list and they're still causing a problem for you, your neighbor doesn't have a duty to control it. It has to be a listed noxious weed. And the case I referred to a moment ago is Krug against Coryell that came out of Rush County, and with respect to the spread of wheat streak mosaic. Ivan Krug, who used to be the county attorney out there, has since passed away, called me one day. And he said, I've got this issue of my neighbor not controlling wheat streak mosaic, and it's getting into my weed and causing a problem. Do I have any recourse? And I said, no, that's not a listed noxious weed. They don't have any duty to control it. He said, well, I'm going to try this case. Well, he did it. He lost. And the court said exactly what I told him they would. There is no common law duty to control weeds that aren't on the state list. Also, most states don't allow civil damages for the spread of noxious weeds unless willfulness can be shown or you can establish a nuisance, and I'll get into what nuisance is in a moment. But you can sue for damages for the defendant's negligent destruction of noxious weeds. And that brings us to a case out of North Dakota. And this was CRP ground that became infested with noxious weeds from the defendant's property. And the plaintiff went over and talked to the owners of Simonson Farm and said, look, would you control your weeds? It's a lot of kochia and Canada thistle and those types of things. And they said, sure, we'll do that. We want to be nice neighbors. And so on a very windy day, they went and fired their combines up and combined the weeds, which created a greater problem. And it caused about $80,000 worth of damage to the plaintiff's crops in terms of reduced yield. And the question was before the court whether the Simonsons owed the Kukowskis a duty to control the weeds in a reasonable manner. And the court said they did. They said combining is not an acceptable manner of weed control. And when they did that, that caused the weeds to spread more than they would naturally, and it increased the problem. In Kansas, the noxious weeds that a landowner has a duty to control. And if you don't, then the counties have what's known as a noxious weed director. Those are those people that drive up and down the roads, and they do what I call drive-by shootings in Kansas. Those are drive-by sprayings. And they will control it, and then they'll send a bill to the landowner. If it's a tenant that is in possession, the tenant really is responsible for controlling the weeds, but the bill's going to go to the landowner, which will probably make the landowner upset with the tenant for not controlling the weeds, and could result in a termination of the tenancy if the landowner is upset enough. But these are the A-list weeds: hoary cress, leafy spurge, quackgrass, Russian knapweed, kudzu, and pignet. Then the B and C weeds, or the B weeds, are Canada thistle, field bindweed, musk thistle, Sericea lespedeza, Johnson grass, burr ragweed. So those are your Class B and Class C weeds. And again, you have an affirmative duty as a landowner to control those on your property, or you run the risk of the county controlling them and sending you a bill for that. So what about nuisance law? We kind of nibbled at the corners of nuisance law there for a moment, but the standard definition of what a nuisance is, and I want you to think about it in the context of where we're headed with this discussion, and that's pesticide drift. A nuisance is an invasion of someone's interest in their use and enjoyment of their land. It's not an interference with exclusive possession or ownership of the land. So no one is interfering with your possession. No one's interfering with your ownership. They're interfering with your use and enjoyment of your property. So the basic principle here is that I have a right to use and enjoy my property in any fashion that I want. You have the right to do the same thing on your property, but we are both bound by a duty of reasonableness to each other. So I have to use and enjoy my property free of unreasonable interference by others. So I can do whatever I want as long as it doesn't interfere with your right to do whatever you want on your property, and vice versa. So you can't injure adjacent landowners in your usage of your property. And that comes from the common law, the non-statutory law, which is what nuisance law is. It's largely common law that's been developed over several centuries as courts have settled land use conflicts. And so nuisance law is always changing, and Kansas nuisance law will be different from Nebraska case law on this issue, or Missouri, or whatever. The legal rules do vary by jurisdiction. And of course, nuisance law is very important to agriculture because primarily of odors produced by many farming operations. But we can get into nuisance, as you'll see, with respect to drift issues. So there are two primary issues in every ag nuisance dispute, and that is whether the use alleged to be a nuisance is reasonable for the area. And then secondly, whether the use alleged to be a nuisance substantially interferes with the use and enjoyment of neighboring land. Now, when we think about this in different contexts, the classic one in agriculture is odors. But this can come up with an organic grower and a conventional grower, or a conventional grower and a genetically modified or genetically engineered grower, a grower that's using genetically engineered seed to grow a genetically engineered crop. And the control of the weeds for the conventional grower might be by spraying, and it gets over onto the neighbor, or you flip it around, you have a drift of the pollen from the genetically engineered crop into the organic crop or the conventional crop. And then let's say that producer has an identity preserve contract for their buyer because they're selling into a market that doesn't accept genetically engineered crops. And then you get into contract issues, nuisance issues, all types of things. So it can be really pretty broad in terms of the issues that can come up. We also see it with trees. Trees in a fence line. I just did one of my daily national syndicated radio shows on the issue of cleaning out a fence line, a fence row. And what if there's a tree in the middle of the line and right in the fence? And sometimes these fences have been there so long that the tree just grows right into the fence. Well, what if there are branches that hang onto one side or the other? What if that's a thorn tree that's dropping thorns on your property, but the base of the tree is on your neighbor's property? And the point of this slide is to show you that there are different rules, again, depending on what state that you're in. And so the obligations and the way we control those might be different. But in ag, the big issue is odors. But the principle, again, my point here is it's the same principle with pesticide drift. The drift of odors and the drift of pesticide give us the same issues. Now, the damage calculation might be different. And that's, I'll get to the damage calculation with a Kansas case toward the end of the discussion. One of the classic cases on this was Bauer against hog builders. This was a Missouri case, Missouri Supreme Court back in 1970. And geographically where this was at was between St. Joe and Cameron, Missouri, not too far off of Highway 36 along the Jordan Creek. And this is one of those, in fact, in that part of Missouri to this day, along that corridor between St. Joe and Cameron, and then as you go up I-35 and go a few miles north and then jog east to work your way up to another highway, I think it's 136 in Missouri. That area to this day has a lot of problems with confinement agriculture, and there you'll see signs that really stem from this major case back in 1970. And there's still some old timers around that remember living through what happened with this case. Here, the plaintiffs sued the defendants for creating a nuisance resulting from their hog operation. And they were noxious odors, discharge of animal waste onto the plaintiff's land, pollution of surface waters, rats, flies. It was just terrible. And the question is whether that constituted a nuisance. And the court said, yes, there was overwhelming evidence. There were compelling facts that required the court to find that the defendants created a nuisance. And so the court awarded actual as well as punitive damages. Now, punitive damages in a tort case are pretty rare. That means that the defendant's conduct was so bad that the court feels that rewarding the plaintiff with actual damage is not enough to prevent the defendant from doing this again. So we're going to punish the defendant by awarding punitive damages to the plaintiff in these situations. But nuisance and negligence are not the same thing. And that's a key point. And we just had a recent decision come out of Iowa where a pipeline company tried to argue that, well, we didn't create a nuisance issue, so we can't be deemed to be negligent. Or we weren't negligent, so therefore there's no nuisance. No. Those two concepts are totally different. And I can't believe that we had a case get all the way to the Iowa Supreme Court on that issue because this is standard law. They are two different concepts. And that's indeed how the Iowa Supreme Court ruled. But operating a farming or ranching activity properly, and this is a key point. If you want to think about pesticide drift, well, is the use of aerial application of chemicals on my neighbor's property that drifts over onto me, is that even a good farming use or permissible farming use in the first place? Is that proper to do that? Do they have permits to do that? And even if they do, operating the farming or ranching activity properly, having all the requisite permits, that may still constitute a nuisance if a court or a jury determines that the activity is unreasonable and causes a substantial interference with someone else's use and enjoyment of their property. That's the key point. So as applied to pesticide drift, what would be unreasonable? Well, applying the chemicals on a very windy day, for example, be negligent to apply it on the wrong tract of land. They directly apply it to you. It's not a drift issue. They just miss the property. So nuisance and negligence are not the same thing. And even if they did everything proper and you still have drift, they can still be held liable for that. So that's a key point. They can't say that, well, we weren't negligent. Okay, you might not be, but it still may constitute a nuisance because the key is, did it interfere substantially with your use and enjoyment of your property? And that's the key point on this. So every case is dependent upon the facts of that case and what are the legal rules in that jurisdiction? And that can differ from state to state, that second point. So how do we determine if an activity is a nuisance? Well, is what is being done, is the activity that you're complaining about, is that a common activity in the area? Or is it not? Now, see, that can come up in the realm of organics and non-organics. If you're the only organic grower and you're surrounded by non-organic growers all around you, then you're kind of the odd duck in the situation. So is your use complained of common to the area? Well, in that instance, it would be no. What if it's genetically engineered crops and conventional crops, and you have one conventional crop grower in a sea of genetically engineered crop growers? Okay, the question of what's common in that situation. Can all the conventional growers claim that you're a nuisance? Maybe so, because you're the only one. You see, that can work both ways. What's the nature of the property, whether the activity substantially interferes with the plaintiff's land use, whether the activity is vital to the local economy, and whether the complained of use predates the plaintiff's use. In other words, who was there first? And that's a consideration too. Courts also in these types of cases have the power to fashion a remedy to fit the particular circumstances of the situation. They can award monetary damages. They can issue an injunction that means stop doing what you're doing, either permanently or temporarily. Just don't do it. Or you can do it, but you're going to have to pay damages. If you do this again, you'll also get hit with a damage award. But particularly when it comes to odors, a court won't issue an injunction to stop the activity that might cause a nuisance. The courts like to allow people to show that they can do what they propose to do without damaging anybody else. So you can't sue in advance to stop someone. For example, you can't sue your neighbor to stop them from crop dusting. The crop dusting has to occur first, and if it damages you, then you sue for your damages. And so this is something that's done after the fact. So you can't stop someone from crop dusting because, unless there's some federal law that would apply. I'll get into that in just a moment. You can't stop the activity before it's done because courts are going to allow them the chance to show that they can do it without causing harm to anybody else. For example, on this remedy issue, the Valasek against Bear case shows you the latitude that the courts have to fashion a remedy. And here in Valasek against Bear, the plaintiffs complained that their neighbor created a nuisance by spreading manure on the portion of his property near their home. And they wanted to stop that. They sued for an injunction. And the question was, well, was the conduct a nuisance? And if so, is injunctive relief proper? And the court said, yeah, it is a nuisance. And therefore, the defendant was enjoined by the court, stopped from spreading manure on the parcel. Here's the way that they fashioned the remedy. Don't put it on the parcel closest to the plaintiff's home. You can spread manure on other land if you knife it in the same day. So that's a flexible remedy to deal with the situation on a case-by-case basis. We've got a major case, in fact, one of the worst nuisance cases I've seen in Kansas right now. It's on appeal to the Kansas Supreme Court, and that's coming out of the Norton/Phillips County area, where you had a landowner that just kind of commandeered the ditch in front of adjacent landowners' property to run hog manure in to another parcel that he owned to pipe it into pivot irrigation so he could spread it there. And it got real close to a home. And so it's got a number of questions, whether it's a nuisance and whether you can who owns the ditch. And the trial court said he was wrong. And this thing is on appeal, and it's to the Supreme Court right now. He's lost all the way through, but we'll see. We'll see what happens. I personally, I hope the Supreme Court just affirms what the Court of Appeals said. I think the Court of Appeals got it right and said he had created quite the problem there, and that we each own the ditches. And if somebody else wants to use that, they have to ask permission for us to do that, or they have to go through the county to do that. The county in this instance had told him no. He went ahead and did it, didn't get permission of the landowners, created the problem. And so the court's going to have to sort that out. The classic case on fashioning a remedy in these types of situations, and I mentioned this because a lot of times you get lower court judges at the county level, district court level, that don't really realize the latitude that they have in fashioning a remedy to fit a situation. You're not stuck into a particular box as a judge in these nuisance cases saying, well, the remedy is X or it's Y. No, you can kind of sit there and fashion a remedy as to what you think might be best. So what you had in this classic Spur Industries case out near Phoenix, Arizona, back in 1972, the genesis of this was back in the 1950s. Del Webb, which is a residential land developer to this day, occasionally you'll see signs if you travel the country that Del Webb has properties for sale. They were developing what became Sun City, Arizona. I don't know if any of you have been to a Phoenix, Arizona Cardinals game That stadium is in Glendale, and that's way out west of downtown Phoenix. Well, you go from Glendale to the north and northwest, and you get about 35 to 45 miles out from downtown. And what you had sitting out there was a big cattle feedlot, way away from any type of development, minding their own business. Well, Del Webb continued to develop and develop and develop and build homes, and they got ever closer to the feedlot, and then they couldn't sell houses because now you got odor, now you got flies. They got too close. So what did they do? They sued the feedlot for interfering with their development of properties. And you would say, no, wait a minute, that doesn't sound right, because the feedlot was out there way away from the development, minding their own business. And Del Webb sued them, said, we can't sell our homes. We're getting resistance here because of the flies and the odor, and that's dampening our home sales. And so they sued to shut the feedlot down. And that was the issue before the Arizona Supreme Court. The Arizona Supreme Court said, yeah, the feedlot's a nuisance, but in a very wise move, I think a Solomon type decision here, they said, Webb, as the developer, you have to indemnify Spur for a reasonable amount of the cost of moving or shutting down. You want them to move? Okay, you pay them. You pay their cost to go somewhere else, and then you can develop that area. I think that's a pretty wise way that the court handled that. I have never seen another court do the same thing. But again, the point here on this little side detour is to show you that in pesticide drift situations, nuisance situations of any flavor, the courts have a wide degree of latitude to fashion a remedy. Okay, and then we have issues with classifying a nuisance. So a private nuisance is just between you and your neighbor, for example, that's based on disturbance of rights, and the remedy lies in the hands of the individual whose rights have been disturbed. The state is not involved. And as long as you have clean hands and you're not creating a nuisance, then you've got a right for redress. And that's a private case, private action that you would file against that neighbor. A public nuisance is a little bit different. And some of you who've been in New Orleans may recognize the street that's there. But a public nuisance is something that's bad for the community at large, and the remedy is in the state's hands. And so a lot of times we think of that as to certain types of establishments that will drag down the community, drag down home values, those type things. That's deemed to be a public nuisance. The remedy's in the state's hands. Back to this GMO issue, in the Starlink litigation a number of years ago, you might remember that a court actually upheld against a motion to dismiss a farmer's private nuisance claim against a seed company for contamination of non-GMO crops, because the court also held in that case that there was a sufficient claim that had been pled for a public nuisance, a contamination of the food supply because of the contamination of non-GMO crops. And in a later case, however, there was no public nuisance for contamination of non-GMO rice. So you get into it in that type of issue also. Then a nuisance per se is just under any circumstance, what this is a nuisance. Relatively few activities are deemed to be a nuisance per se under every situation. And then another one, just to be complete here, is a nuisance per accidens. That is an activity that becomes a nuisance because of surrounding circumstances. What about wind farms? Well, let me just throw this in. We could throw in solar farms too. What about aesthetic view? Can you sue for nuisance based on aesthetics or emotional impact? And the courts don't like to do that, and they stay out of that. And I show as an example here the Texas Rankin case against FPL back in 2008. They said, no, Texas law doesn't recognize a nuisance claim if the only basis for the claim is aesthetics or emotional impact. You have to show some actual physical economic loss in that situation. There was a Birch case back in 2007 involving wind farms, and this one, the court did say constituted a nuisance because there was evidence of turbine noise, light flickering, broken blades, ice thrown off the blades, collapsing towers, and reducing adjacent property values. And if you saw the pictures out of Iowa this spring, near Greenfield, Iowa, there was an entire commercial wind farm where the towers were just snapped like pencil sticks. And there will be lawsuits come out of that with the damages. Of course, the Zimmerman case in Kansas involving the Flint Hills. Okay, potential defenses. I was there first, so I have priority of location. and right to farm laws. Kansas has a right to farm law, and I can have a defense to a nuisance action if I meet the requirements of the statute. Now, let's hone in on pesticide drift, the specific topic. So that kind of lays the background that really we're talking about nuisance law and showing you different areas of where that can be applied and what the basis for nuisance law is. But pesticide drift is any airborne movement of pesticides from the target application site to any unintended areas. So pesticides can drift for as much as several miles. And we're seeing that. I'll talk about dicamba here in just a bit, but some chemicals are far more volatile than other chemicals are. And it depends when they're applied. With dicamba, it's heat that increases the volatility of that. It can move off-site a couple miles. And that has created of course, the dicamba multi-party litigation in numerous states. So that's one principle. And then drifting pesticides might be apparent as a cloud of droplets or vapor. There might be dust particles during application, or even as a noxious odor that can linger after application. So there we are, back pesticides and an odor issue that leads us into the classic livestock odor issue that we find in agriculture. But drift cannot have an odor, or it may be invisible, or it may persist for days. So you can have those situations that occur too. So drift can happen when regardless of whether the application is aerial or whether it's ground spraying. It's more prevalent when it's aerially applied. Ground, of course, you're closer to the ground and there's less chance that the wind can move that, as well as from applications that volatilize and move through air currents that expose people and animal and crops and trees and non-plant crops to toxic chemical compounds. So most typically, we're talking about insecticides and herbicides and fungicides. So the key there is, yeah, it can damage my crops, but it also might harm my animals. It also might expose people to it, particularly other farm workers and their families. This not so much an issue in Kansas on farm workers, but it is when you have hand-picked crops out in California or in Texas, and you have field workers that are out there. They can get sprayed and get exposed to it. And you have soil and water resources that can become contaminated, as well as the air that people are breathing. So a whole host of potential problems with respect to offsite drift. And it can cause acute poisoning or chronic health impacts, as I mentioned, in farm workers or anyone that's in the actual application area or working in nearby fields that are being treated. And included among those that are high risk from drift are farm workers and families who live near ag parcels. And there are studies out there, numerous studies on the impact on small children in particular. And it can also occur in other settings. Now, the Kansas pesticide law, let's deal with what I call this first things first. What is the pesticide? What are the key provisions of the pesticide law that might apply in drift situations? Well, in general, the statute says that it's unlawful for anyone to use a pesticide in a manner which is inconsistent with the label. Okay, that's a key point, because while Kansas does not have specific laws dealing with drift, some of these labels do talk about drift. And then since the statute says it's unlawful to use a pesticide inconsistent with the label, that can help you in a drift damage case. And indeed, subsection B acknowledges handling risk. It's unlawful, the statute says, to discard or store any pesticide or pesticide container in such manner as to cause injury to humans, vegetation, crops, livestock, wildlife, pollinating insects, or waterways and wildlife therein. So there is an acknowledgement that there's a risk with respect to pesticides. And of course, the statute says that you have to use any pesticide in accordance with the label on the product. So does that cover drift issues? And I think perhaps it does, because again, most of those label provisions have a clause that restricts application in windy conditions in areas that are nearby or adjacent that are deemed to be sensitive. So the applicators need to follow those label use instructions. And usually there's some type of buffer zone that's specified on the label. And so that can be helpful because of the Kansas statute that says it's unlawful to use a pesticide inconsistent with its label. And also many labels will restrict application in situations where drift could occur to food, forage, or other plantings that could be damaged. But there's no clear definition in Kansas law of chemical drift, and there's no listing of any punishments or consumer protections against drift. But if you have a commercial applicator, they have to pass a core examination that includes knowing the hazards that might be involved in applying pesticides. And that includes a number of things that you can see there. They have to know the effect of the drift of the pesticides, the proper meteorological conditions for application, weather conditions, including wind, the effect of the pesticides on plants or animals in the area, the effect of the pesticides to 16 wildlife in the area, including aquatic life, and the likelihood of contamination of water or injury to persons, plants, livestock, pollinating insects, and vegetation. So commercial applicators are definitely held to a higher standard than would be a private applicator. Most of your applicators will be commercial. And that's done for liability reasons, because the farmer, even if they can pilot a plane or a helicopter, they don't want to do that themselves. They prefer to hire that done, because if there's a liability issue, then that's on the independent contractor. That's not on the farmer. Whereas it would be if they did it themselves. Plus, commercial businesses have to keep operational records, such as pests or pests to be controlled, concentration, rate of application, the date, the location, the wind direction, and velocity, and record keeping for certified private applicators using restricted use pesticides. That's also required. So if you get damaged, you need to know that if it's by a commercial applicator, then they have to keep these records. Those records are going to be there, and you would want to have those records subpoenaed, and so that you have them to establish your case. But private individuals that use general use pesticides, now not the restricted use pesticides, but general use pesticides, don't have to go through licensing or training or record keeping. They don't have a liability insurance requirement. So in Kansas, anyone can legally apply chemicals without any formal supervision or advanced education, aside from what's specified in the label's instruction. Again, I come back to the label. What does the label say? And the law says you have to follow the label. Well, if you've got a pesticide drift issue and you want to process a claim or file a claim, how does it get processed? Well, you file a report in Kansas with the Secretary of Ag within 60 days after the date the damage was noticed. And you can file that online. And then the Ag Department will send out an investigator. They can, at their option, inspect the site, take photos, interview witnesses, and get statements, and take lab samples, and check weather records, and so forth. So that's what the Ag Department will do. Drift Watch is a registry, and that's an online sensitive crop registry, and that will allow you to register your property so that we have voluntary communication and mapping for producers and pesticide applicators to be aware of sensitive or organic sites, sites that cannot have the application of pesticides, or you end up in the organic situation losing your license, and it can be very, very costly. And producers have to enroll their farms to be on the list. Now, it's really unclear whether KDA continues to update the data in DriftWatch and just how current that data is. And there's your web address to find that. Now, a case example on this involved a few years ago. This was about 2 years ago was the opinion that came out in California. The Alpine Helicopter Services case involved 4 spray drift or chemical trespass incidents. It involved a drift onto an adjacent farm in 2014. Then they got drift on a school, on a sports complex, and a residential yard. This is after they had been warned time and time again. It still kept happening over this 6-year period, 4 different events in 6 years. Well, in March of 2 years ago in San Joaquin County Superior Court, the court found that the applicator, which specialized in pesticide applications for government and tourism entities, had violated California pesticide drift laws and in the process endangered public health and safety. California's got a different set of pesticide drift rules than we have here in Kansas, but that was one where the court said, well, you violated the rules, and you're going to have some liability for it. Then, of course, there's the whole dicamba debacle, this multi-party litigation kind of centered in southeast Missouri in the Boot Hill area. And it's a label use issue. Dicamba, as you know, was undergoing different formulations of dicamba, and USDA really got out in front of itself on this before the regulatory community caught up. They approved a new label use, the regulations weren't in place, and a new product that was more volatile, and I shouldn't say label use, but a new product that was more volatile. And farmers used it in accordance with the old product, which was not approved by this label. And there's a lot of confusion, created all types of problems, but it has to do with the volatility issue. And some states have since jumped in and said you cannot apply dicamba during certain times of the year, basically the hot times of the year. Dicamba does drift a lot. On the damage issue, I want to take a moment to talk about damages, then we'll get into some questions here. Ringneck Farms case is a Kansas Court of Appeals case in 2020. And this is a ranch that was used for commercial hunting purposes that was adjacent to the Stewie's property. And the ranch had a row of hedge trees about 20 yards wide and 300 yards long on the border of the properties. And the defendants, the Stewie's tenant, asked Ringneck Farms for their permission to cut down the hedgerow to put in a fence. And the plaintiff said no, because this is a commercial hunting operation that has benefits to us as a commercial hunting operation, whereas a fence does not. Birds can nest in there. It's a hiding place for animals that they would have hunters come in and hunt their property, and that's a fee-based operation. So that was attractive to them to have that hedgerow. So they said, no, don't disturb the vegetation, just leave it alone. We want it the way it is. Well, why do you suppose we have a case? Well, it's because the defendant didn't listen to that and went ahead and destroyed 156 mature trees. And the issue in the case is, all right, how do we measure the damages? And so this really brings it home on the pesticide issue. How do I measure damages? And the claim was, and these were mature trees, the claim was that the loss of mature trees decreased the value of the ranch for hunting purposes, which it did. But how do you determine the cost? Well, they hired arborists as experts, which hiring an expert is not cheap. And they determined that the replacement cost would be $1,092,361. Now, that is to find mature trees in a nursery someplace and come out, buy those trees, plant those trees, dig the holes, make sure you get the root base established and all of that. This is not like I do for my place north of Topeka. I buy a couple hundred trees from the state nursery every year, and it's about 60 cents to $2 per tree. And we put those in as I'm developing kind of a conservation place on my farm north of Topeka. Different story. I have death loss on those. They don't all survive, and you have to replant, or my farm hands run them over or mow them, and then I have to whack them around. That's not $1 million replacement cost. It might be $2 per tree. Okay, but these are mature trees. So what do you do in this instance? And this went to the Kansas Court of Appeals, and the court said, okay, we're not going to entertain evidence. The trial court said, we're not going to entertain evidence on replacement value. And this went on appeal, and the Court of Appeals said, well, the plaintiff, the ranch, had not abandoned their claims for conversion and trespass. So those claims are still alive. You can sue for trespass. You can sue for conversion of your trees, civil conversion, not criminal conversion. And the appellate court said, yeah, the trial court was right. We're not going to talk about replacement value. So that's off the table. And then they set forth the rule in Kansas. The general rule in Kansas on measuring damages is the before and after value for negligent destruction of trees. So I want to make clear, that's what I'm talking about here. If you have trees that are damaged, or you could extend this to flowers in flower beds, what's the before and after? At least I think it would stretch to that. What's the before and after value? But the court said, yeah, that's the general rule, but the parties can present evidence if the trees have value independent of the land. And so they come in, let's say we've got fruit trees. Well, the fruit produces an economic product separate from its value as attached to the land. So it produces peaches, it produces apples, whatever. And the court said, well, there might be sentimental value associated with it. This is a tree that as a young boy, my father died when I was 11. I remember planting trees with him on our farm in Indiana, and there are trees there to this day that were planted over 50 years ago that are beautiful, massive trees. Those have sentimental value. If somebody sprayed that, yeah, if that were in Kansas, I don't know how the Indiana courts would deal with that, but the Kansas courts could say if you can establish sentimental value, something unique, we might be able to put a dollar amount on that. And then in this case, hunting quality, it affected the quality of the purpose for which the plaintiff was using their property. And so the court remanded this, sent it back to the Court of Appeals to determine the damages based on this analysis. So ringneck farms, I think, is relevant for computing damages from pesticide drift. That's going to be the analysis that the court would use if you got into litigation on this issue. Plus, that's relevant for negotiating some type of settlement with your neighbor. Okay, I'll stop with that. And we've got about 15 minutes. I wanted to hit 12:45. We made it at 12:46. And Ryan, that you had sent to me by email a number of questions that had already come in, and I went ahead and wrote out my responses to those. Do you want to read them, or do you want to have me read them and then answer them, or how do you want to do this?
I'm not sure I have them, so if you're willing
Okay.
to read them, that would be
Okay.
excellent. Thank you.
First one is, I've seen 2 recent vineyard drift lawsuits in Kansas. Neither of them resulted in restitution. What can we do differently? Now, the way I would answer that one is not knowing the facts and what approach that was utilized in that situation, what approach you took to try to get recovery for your damage. You might want to use the Kansas Ag Mediation Service. That's an option that's out there. That's run through K-State. And full disclosure, I am the attorney for Kansas Ag Mediation Service, but that's a free service, largely free. There might be, a filing fee, or if you use any of the consultants, there's a fee for that, but it's largely a free service funded by USDA and run through K-State. And that's been around since the farm crisis in the 80s. So maybe try to mediate with your neighbor if they're open to doing that. Second question, who do you call when you have property damage? Well, the local sheriff's office for potential criminal matters. For civil matters, if you can't work it out individually, and I would always start there, try to work it out individually. If you can't, then it would be either a private attorney or I would say the Kansas Ag Mediation Service. Next question, and I think, Ryan, you'll get into this. I'd like to know all the places to register my farm as a no-drift property. And one of the things I mentioned in the presentation was Drift Watch, and that's one location, and there may be additional comments you want to make on that. Next question, are there any legal implications for crop duster planes flying over the top of a specialty crop area? That always provides the possibility of drift. The flying in and of itself is not the issue. The application of the chemicals is the issue. So you want to know wind speed, weather conditions, type of chemicals, type of crop it was to be applied on. Did they get the right area and it was drifted, or did they spray the wrong area? All those types of things. Those would be the legal issues that can, facts that bear on the legal issues. Next questions are, what are the regulations regarding airspace over our property? They buzz very close to us, the writer says here. That's a great question. There's actually a fourth U.S. Court of Appeals for the Fourth Circuit case on this. And in that case, they invoke some of the FAA regulations, Federal Aviation Administration. In that case, the FAA got a complaint about a crop duster that was flying too low over an intersection in 3 nearby homes. And so the FAA assigned an inspector to the matter, and they came out to the area to investigate the low-flying issue, and they ultimately issued a warning to the crop duster that he has to file what was known as a congested area plan before he would fly over any possible congested area, or if he didn't, the agency would file an enforcement action. So the first issue there, you can trip federal law if it's deemed to be a congested area. They have to file a plan with the Federal Aviation Administration before they can crop dust in that situation. So the crop duster in the case inquired about the meaning of congested areas. Well, what is that? And the investigator responded by saying that there was no precise definition that existed, and that's true. So the only advice the investigator offered was that a group of as fewer as two or three homes might be considered to be congested. And so the implication was you need to file a plan in this area. And while the filing of a plan is not an admission that the proposed flight zone is congested, it does serve as a safeguard against FAA enforcement action. Well, in the months following that investigation, what happened was he had been warned, months went on, he flew his plane in the same intersection. He never filed a congested area plan before his flights. And so the FAA got more complaints from neighbors in the area on this low flying issue. And so the FAA instituted an enforcement action against the crop duster, as well as the farmer that hired him. And then they looked at the evidence. So now you're in the administrative process in the FAA realm. And they said, yeah, the evidence points to the fact that this was a congested area. And while that's determined on a case-by-case basis, and even though there were only 2 or 3 homes in the area of the intersection, there were at least 30 homes in the general vicinity of the intersection. And so the neighbors' complaints showed that the crop duster passed over the general vicinity at a very low altitude, and that all supported the finding that it was indeed a congested area. So I think the lesson of that case is pretty clear. Federal regulations that govern crop dusting can come into play when the crop dusting occurs where there's even a minimal amount of people located there. So you want to keep that in mind too. Next question, how to get legal representation, statute of limitations for filing a civil case for pesticide drift damage. Well, 2 questions there. How do you get legal representation? One is just to ask around. I get questions about legal representation all the time. Who can I refer people to? So maybe I can point you in the right direction, but ask your neighbors if they've had experience. Ask your own personal attorney if you have one. Can you handle these types of cases? If not, who would you refer me to? And then on the issue of statute of limitations for filing a civil case for pesticide drift damage, that's 2 years. 2 years to file a case. Now that's 2 years from the date of injury or 2 years from the date of discovery, because what you can have in a pesticide drift case is you can have the drift, and you may not notice any damage to your plants, your trees, your vineyard for some time. There may be a time lag. So it's 2 years from the later of date of injury or date of discovery. Next question, how is actual damage caused by herbicide drift assessed and quantified? Well, that's going to be done by expert witness reports and testimony. So you're going to hire an expert. Might be an agronomist, might be a soil scientist, might be an arborist, depending on what the damage is to. And they'll come out and do their work, and they'll write a report and give testimony. Now, that's costly to do that, which is going to feed into another question here in just a moment. 5 years ago, the next question, we were sprayed our first year growing. Attorney said if we didn't have $10,000 in losses, they weren't interested. Yeah, those bad attorneys, I tell you. But the reason you got that response is they did a calculation and they figured that it's probably going to cost you more than what you would recover. So try to mediate that type of dispute. And again, some people, it's the principle of it. And I've seen people will spend $40,000 to get 10. So take that with a grain of salt. But that's because they are looking out for your best interest, and they're saying, well, look, we're anticipating it's going to cost you X because of the time we're going to have to spend in this. And that's more than what you would possibly recover. That just does not make sense. In the United States, unfortunately, in these types of situations, we follow the American rule. We don't follow the English rule. And that is that if you win your case, you don't get the loser's fees. You don't make them pay your fees. That would be nice in these situations, but that's not the way it works. So how large does the economic damage have to be before it's worth pursuing damages? That ties into what I said earlier. You're going to have to hire that expert witness. You're going to have to prove up your damages. That's expensive. The time to prepare the case and argue the case and all of that. So based on the previous answer, at least $10,000, if that's what someone was told, probably more than that. Okay, what can be done when a neighbor continues to spray with the wind blowing into our vineyard over and over again? What you want to buy are really big fans and turn them on and point them on your neighbor. Now, go back to the discussion of the FAA rules. If it's a congested area, then those FAA rules might come into play. But first of all, talk to the neighbor and the company doing the spraying. If your neighbor won't talk to you, the company is likely an independent contractor, and they should listen to your concerns and realize that if you're upset, if you're concerned about these things, they could get sued. It won't be your neighbor that would have liability because they hired an independent contractor, and it's the independent contractor that's liable. So talk to that company that's actually doing the spraying. Next one, is there a checklist of what a producer should do when they see adjacent spraying? Well, I would say make a list of the day, the time, the type of crop sprayed, the weather conditions, the wind speed. Get that NOAA report, the weather report from either the national NOAA, the national system, or local reports for that day. Get the type of aircraft, the company that's conducting the spraying, all those types of things. That's your starting point. And then take pictures and maybe video, live video of the actual spraying occurring, pictures before and after of your crops or your plants, whatever the situation might be, to be able to show before and after. Because as we noted in the ringneck farms case, that's where the damages generally, or how they're going to be calculated, is before and after. Aircraft drift, the next question, could they be required to send all those registered in a no drift area a notification of when and what is sprayed? And that one is, I'm not sure. I think so, but I'm not positive on that one. So that's a quick run through of the questions that were submitted that I saw in the email that you sent me, Ryan. I'm sure there'll be other questions that people have. We have just a few minutes left here, but hopefully we got through some of the questions that you had.
Yeah, thank you, Roger. That was really helpful. I learned a lot just now. I mean, the whole time. Had a couple questions. Let's see. Do you know what the final judgment of the damage value was in that ringneck case?
I don't. I haven't seen anything come through. It may have been settled. The only way I would know that is by contacting the attorneys and asking if it's been settled and whether they can disclose it.
Mm.
So I don't know. That's a great question. It's always nice to know. Well, for the older ones that have been around a while, it's nice to know the rest of the story, as Paul Harvey would say.
Yeah.
Charlotte may not even know who Paul Harvey is.
Am
I right or not?
Oh, I know who Paul Harvey is.
Okay. Do you know what the Hotel California is, Charlotte?
I do.
Oh, okay. All right.
Roger, she's actually older than I am, so he should be pointing those at me probably.
Well, do you know what the Hotel
I
California?
do.
Oh, okay.
So we had a question. Are farmers obligated to tell you what they sprayed on a field close to your home if you ask them, or if they're a private applicator? Is there any kind of requirement of disclosure?
Obligated? Probably no. But if you have that conversation with your neighbor in advance as to what type of crops that you have or what your concerns might be, then there might be an option that they have in terms of the chemicals that they can apply that wouldn't cause a problem for your plants or your trees or your crops, and would still do the job for them. That's something I always try to emphasize. Communication with your neighbor is always best in these situations. And I understand that's difficult in some instances because sometimes neighbors don't want to get along. But try that first. There may be options that they have that they can use the pesticide that wouldn't affect your crops or your plants.
Yeah, good communication is key. I had a question about a lot of spraying being done all the time. Can it be pinpointed reliably? When you're surrounded by fields. I would imagine that's hard to establish that. And going back to some of the guidelines you were talking about, photos of your crops, knowing, that when people are spraying nearby you, noting the date.
Okay, so the question there I thought was going one direction. I think it ended up a different direction. And that is, if there are multiple sprayers in the area, how do you determine which one damaged your crops? Is that what it is?
I think so, but they could chat more if they want to.
And that could be the case. You could have multiple farms and different crop dusters and not know where the drift is coming from. So that's that is an issue that's out there. And that might have been what's being asked. And that is very difficult unless you can pinpoint the type of damage to your crop might be caused only by a particular chemical. And your agronomists at K-State, your extension agronomists that come out and look at the field might be able to tell you, well, this is the indication of damage by chemical or pesticide X as opposed to Y. They might be able to do that for you. And therefore, then you can take that the next step and determine, all right, which of my neighbors applied X as opposed to Y, and maybe find out who the culprit was in that instance. If that was the question, that's how I would attack it.
I think so. Are there other questions, or did I miss anybody in the chat? Please chime in if so. Is a producer obligated to contact surrounding farms about the crops they will have planted, like enlist beans versus other beans?
Perhaps, yeah. If you're in a buffer zone that is if there's a buffer zone that I go back to the label use, if there's a buffer zone indicated on a label and the individual is contemplating spraying, and we're in the springtime before crops have been planted, but they know what their practice is going to be, you need to have that conversation so that you don't end up in a buffer zone that would violate someone's label use. So we want to avoid that type of problem. Then if the spraying occurs, that can be deemed a violation of the label, which under Kansas law makes it unlawful in terms of the way it was applied. So that's the way you would step that through.
Okay. I don't know if that answered that question. I guess chime in if not. But I will note just a couple of things quickly about the KDA complaint process and Drift Watch. I put those in the chat earlier, and Roger had those in the presentation as well. Drift Watch, again, is just a voluntary communication tool, I think kind of similar to just talking with your neighbors and checking that. But I don't know that there's any legal requirement for a applicator to check the registry to make sure that they're staying away from your property. Do you know if there's anything like that, Roger?
I don't know. It's a good question.
I would imagine there's not. But that is something, you know, it's one step that's fairly easy to do that could possibly make a difference for you. You can also get signs from the Drift Watch registry that you could put up near your property, and perhaps applicators that are going to be spraying near you might see that and might be more careful. You know, it's all kind of theoretical, but it wouldn't hurt certainly to do that if you are working in a sensitive area or have sensitive crops. And the other one I put in the chat earlier was KDA's complaint form, and there's a couple different pieces of that which kind of fall along the lines of a damage claim, a misuse claim, or other claims. And I think, as I understand it, you can request those damage claims, but that is primarily, I think, for KDA to kind of back up your note that that damage has happened. They'll help you get in contact with the person who sprayed and try to work with them and work with you. But I don't think that the complaint form is not to push KDA to pursue damages against that person necessarily,
right.
Unless it's a misuse kind of thing. So those are some of those options there. And as far as I know, and what Roger's talked about today, those are kind of your avenues for pursuing any kind of penalties or anything like that. Are there any other questions, or Roger, do you have any wrap-up comments that you want to make?
No, I don't think so. Those are good questions that were submitted that went through. And again, if you have questions, you can send them to Ryan. He can get them to me, or you can ask me directly, and I'll get to them as fast as I can.
Well, yeah. Thank you so much for your time, Roger. We really appreciate your expertise, and everybody can give the Zoom clap applause for Roger. Yeah, as Charlotte was saying earlier at the beginning, we're looking to, as we hear from people, see what kind of avenues for change there might be. And so we'll send out an email with the recording and a form you can fill out to kind of talk about your experiences. And there's not any kind of we might be able to change the way some things are carried out, or look at policy solutions. So, but we need your input on what you're looking for and what problems you've experienced. So, if you please fill that out, and we appreciate your time. So, thank you all for your attendance.